Hello students, I hope that you're all doing fine. In this lecture, we're going to continue with appropriation of payments and finish the concept of discharge by agreement. So let's begin. So when a debtor owing several distinct debts to one person makes a payment which is not sufficient to discharge all the payments, the question arises to which particular debt the payment is to be applied. The Act in sections 59 to section 61 lays down the underlying principles. Section 59 says that application of payment where debt to be discharged is indicated. Where a debtor owing several distinct debts to one person makes a payment to him either with express intimation or under circumstances implying that the payment is to be applied to the discharge of some particular debt, the payment, if accepted, must be applied accordingly. So it has following illustrations where A owes B among other debts 1000 rupees upon a promissory note which falls due on the 1st June. He owes B no other debt of that amount. On the 1st June, A pays to B rupees 1000. The payment is to be applied to the discharge of the promissory note. A owes to B among other debts the sum of 567 rupees. B writes to A and demands payment of this sum. A sends to B 567 rupees. This payment is to be applied to the discharge of the debt of which B had demanded payment. Section 60 says, application of payment where debt to be discharged is not indicated. Where the debtor has omitted to intimate and there are no other circumstances indicating to which debt the payment is to be applied, the creditor may apply it at his discretion to any lawful debt actually due and payable to him from the debtor, whether its recovery is or is not barred by the law in force for the time being as to the limitation of suits. Section 61 says, application of payment where neither party appropriates. Where neither party makes any appropriation, the payment shall be applied in discharge of the debts in order of time, whether they are or not barred by the law in force of the time being as to the limitation of suits. If the debt are of equal standing, the payment shall be applied in discharge of each proportionately. So, the following ideas are what we see as a result of these sections. Number one, appropriation by debtor. The first principle is laid down by section 59, which confers the right of appropriation upon the debtor. If the debtor owes several distinct debts to the same creditor and makes payment, he has the right to request the creditor to apply the payment to the discharge of some particular debt. If the creditor accepts the payment, he is bound by the appropriation. This principle was laid down as early as 1816 in the case of Clayton and has since been incorporated in this section and also followed in a number of cases. Further, as held in Munnu BB versus CIT, this principle applies to several distinct debts and not a single debt payable by installments. So, a question was asked in UPPCC 2003, it said, which of the following sections of Indian Contract Act embodies the rule of Clayton's case relating to appropriation of payments? And as you already know, the answer is section 61. So it has been held in the case of Gurpreet Singh versus Union of India that this set of sections is applicable only in cases where more than one debts are due from the debtor to the creditor. Once again, the same idea. They are not attracted when there is only one debt, or as in this case, the debt has become merged into a decree. The second idea that follows through this section is that of appropriation by creditor. It is laid down in section 60 and it enables a creditor to make appropriation. If the debtor makes payment without any appropriation, the creditor may use the payment at his discretion to wipe out any debt which is due. In Meghraj versus Bayabai, where a mortgagor deposited some amount in the court without indicating whether it was for principal or interest, the court held that the ordinary principle that such money should first be applied to interest and costs and then to principal would apply. The last idea that we see is given in section 61, which is appropriation by law. This section applies when neither party makes an appropriation. In such a situation, the law gets the right to appropriate the payment and the law prefers to wipe out the debts in the order of time in which they were incurred. Now that we have finished the idea that appropriation of payments is, and I feel that I have given it significant time, that is whatever time that it deserves in relation to how many questions have been asked from this set of questions and how important it is for this competitive exam. So now that we have finished this given set of sections, we are going to continue with discharge by agreement. So contracts which need not be performed. Section 62 says effect of novation, rescission and alteration of contract. If the parties to a contract agree to substitute a new contract for it, or to rescind or alter it, the original contract need not be performed. It has following illustrations. A owes money to B under a contract. It is agreed between A, B, C that B shall thenceforth accept C as his debtor instead of A. The old debt of A to B is at end, and a new debt from C to B has been contracted. Illustration B. A owes B rupees 10,000. A enters into an agreement with B and gives B a mortgage of his estate for 5,000 rupees in place of the debt of 10,000 rupees. This is a new contract and extinguishes the old. Illustration C. A owes B rupees 1,000 under a contract. B owes C rupees 1,000. B orders A to credit C with 1,000 rupees in his books, but C does not assent to the agreement. B still owes rupees 1,000. B still owes C rupees 1,000 and no new contract has been entered into. Now, starting with the very idea of novation. What is novation? So it has been held in the case of Scarf versus Jardine. When the parties to a contract agree to substitute the existing contract with a new contract, that is called novation. And in this given case law, Lord Selborne explained the meaning and effect of novation in the following words. There being a contract in existence, some new contract is substituted for it either between the same parties or between different parties. The consideration mutually being the discharge of the old contract. A common instance of it in partnership cases is where upon the dissolution of a partnership, the persons who are going to continue in business agree and undertake as between themselves and the retiring partner that they will assume and discharge the whole liabilities of the business, usually taking over the assets. And if, in that case, they give notice of that arrangement to a creditor and ask for his accession to it, there becomes a contract between the creditor who accedes and the new firm to the effect that he will accept their liability instead of the old liability, and, on the other hand, that they promise to pay him for that consideration. Hence, novation can be of two kinds, namely, a novation involving change of parties, and secondly, a novation involving substitution of a new contract in place of the old. So starting with the first category, that is change of parties. The first illustration to section 62 is a case of novation by change of parties. We see that if A is a debtor and the creditor agrees to accept B in his place as the debtor, then the original contract between the creditor and A is at an end. As held in the case of Bhaskaruni Venkata Narayan, Bhaskaruni Lakshmi Bayamma, a novation of this kind usually takes place when a new partner is admitted into an existing firm, or when a partner retires from a firm and the new firm, as constituted after admission or retirement, accepts the liability of the old firm, and this is approved by the persons dealing with the firm. Throughout this while, concurrence of all the parties is necessary. The second is substitution of new agreement. So when the parties to a contract agree to substitute a new contract for it, the original contract is discharged and need not be performed. It is necessary for the application of this principle that the original contract must be subsisting and unbroken. The substitution of a new contract is not possible after there has been a breach of the original contract. And an early illustration of this given phenomena is that Manohar Koyal versus Thakurdas Naskar. So here the plaintiff sued to recover the sum of rupees 1173 due on a bond. After the due date of the bond, the plaintiff agreed to accept rupees 400 in cash and a new bond of rupees 700 payable by installments. Subsequently, the defendant neither gave rupees 400 nor the bond. So the plaintiff here sued him on the original bond. The Calcutta High Court held that the original contract was discharged not by novation but by breach, and the plaintiff was entitled to sue for the breach of the original contract. Thus, in the words of the Supreme Court in the case of Lata Construction versus Ramesh Chandra Ramnikal, as spoken by Justice S. Sagir Ahmed, one of the essential requirements of novation, as contemplated by Section 62, is that there should be complete substitution of a new contract in place of the old. It is in that situation that the original contract need not be performed. Substitution of a new contract in place of the old contract, which would have the effect of rescinding or completely altering the terms of the original contract, has to be by agreement between the parties. The substituted contract should rescind or alter or extinguish the previous contract. But if the terms of the two contracts are inconsistent and they cannot stand together, the subsequent contract cannot be said to be in substitution of the earlier contract. Now, the contract in the case was to provide a flat. A subsequent contract between the parties provided that the rights of the buyer under the original contract would be extinguished only on payment by him of the stipulated amount. Here he failed to make the payment, and it was held that he could invoke the terms of the original contract and claim before the Consumer Commission that there was a deficiency in service on the part of the builder. Now, there has been a case where we see that there is no effect upon arbitration clause, and it is that of S.K. Sharma versus Union of India. So here, where the signature to a settlement agreement were procured by coercion, it was held that the arbitration clause in the original agreement did not become discharged. The dispute was of a nature which was arbitrable under the original contract. It made no difference that a settlement agreement was entered into between the parties. Now, section 67, it says, effect of neglect of promise to afford promiser reasonable facilities for performance. If any promisee neglects or refuses to afford the promiser reasonable facilities for the performance of his promise, the promiser is excused by such neglect or refusal as to any non-performance caused thereby. So it has an illustration where A contracts with B to repair B's house, and B neglects or refuses to point out to A the places in which his house requires repair. Here A is excused for the non-performance of the contract if it is caused by such neglect or refusal. Now, talking about the idea of interdependent promises, where promises are interdependent so that one party cannot perform without cooperation of the other. If the latter does not provide reasonable facilities for performance, then the former is excused from his obligation to perform. And the illustration appended to section is based upon the case law of Macon versus Watkinson. It would help to remember that just in case a question comes in prelims, because many a time questions are asked that way. Now, talking about rescission and restoration, this given section, it also permits the parties to rescind their contract. And the Supreme Court in the case of Syed Israr Masood versus State of MP has allowed the parties to rescind under this section a contract for sale of forest scoops because of the substantial variance between the particulars of quantity and quality of timber held out at the time of the auction and the timber actually available. The contractor was allowed a refund of his deposit, but here no compensation was allowed to him for his loss because the contract contained a clause against compensation in such circumstances. Now, talking about section 63, which is that of remission of performance. Yes, section 63, it allows the parties to a contract to dispense with the performance of the contract by the other party, or to extend the time for performance, or to accept any other satisfaction instead of performance. It says, promisee may dispense with or remit performance of promise. Every promisee may dispense with or remit wholly or in part the performance of the promise made to him, or may extend the time for the performance, or may accept instead of it any satisfaction which he thinks fit. It has 5 illustrations. The first illustration says, A promises to paint a picture for B. B afterwards forbids him to do so. A is no longer bound to perform the promise. Illustration B. A owes B rupees 5,000. A pays to B and B accepts in satisfaction of the whole debt. 2,000 rupees paid at the time and place at which the 5,000 rupees were payable. The whole debt is discharged. Illustration C. A owes B rupees 5,000. C pays to B rupees 1,000 and B accepts them in satisfaction of his claim on A. This payment is the discharge of the whole claim. Illustration D. A owes B under a contract a sum of money, the amount of which has not been ascertained. A, without ascertaining the amount, gives to B, and B, in satisfaction thereof, accepts the sum of rupees 2000. This is a discharge of the whole debt, whatever may be its amount. A owes B rupees 2000 and is also indebted to other creditors. A makes an arrangement with his creditors, including B, to pay them a composition of 8 annas in the rupee upon their respective payments. Payment to B of rupees 1000 is a discharge of B's demand. So what we see is that the effect of the provision here is that the party who has the right to demand the performance of a contract may either number 1 remit or dispense with it wholly or in part, number 2 extend the time for performance, number 3 accept any other satisfaction instead of performance. Now talking about acceptance of less sum. So the acceptance of a less sum of money where more is due is a good discharge of the whole of the liability. The Supreme Court's decision in Kapoor Chand Goda versus Mir Nawaz Himayat Ali Khan Azam Jah illustrates this. The liability was about 27 lakhs of rupees. Hyderabad having been taken over, a committee was appointed to clear matters. It offered 20 lakhs to the creditor in full satisfaction and he accepted it. Afterwards, the creditor sued the debtor for the balance. Here, Justice S.K. Das held that the facts of the case are completely covered by Section 63 and the illustration C thereof. The appellant, having accepted the payment in full satisfaction of his claim, was not entitled to sue. The court also relied upon Section 41, which provides that when a promisee accepts performance from a third person, he cannot then afterwards sue the promisor. Similarly, in the case of Harichand Madan Gopal versus State of Punjab, the Supreme Court held the government had decided to recover only 40% and no more. The government's decision would amount to remitting a part of the debt due by the appellants. Therefore, the government cannot ask to recover more than 40%. Now, in relation to the idea of acceptance of payment under protest and additional work, we have an important case law, that is R.L. Kalethia and Co. versus State of Gujarat. Here, the contractor accepted the amount mentioned in the final bill under protest. The contractor company had performed additional work on the directions of the department. The court said that the contractor was entitled to additional amount or by way of damages as per the terms of the agreement. The mere fact that the contractor had accepted the final bill, it could not be deprived of its right to claim damages for the additional work, which was a provable fact. Now, in relation to waiver, to dispense with means that the party entitled to claim performance may waive it. The Supreme Court has already laid down in the case of Vaman Srinivas Kini versus Ratilal Bhagwan Das and Co. that waiver is the abandonment of a right which normally everybody is at liberty to waive. Further, an extension of time for performance by mutual consent is not the same thing as a waiver, and this distinction has been emphasized by the Supreme Court in the case of M. Sham Singh versus State of Mysore. Here, M was granted scholarship by the state for higher studies in the United States upon a bond that he would serve the state on his return, provided that the state offered him a job within 6 months of his return, failing which the bond was to be taken as waived. If M failed to comply, he was to refund the scholarship money, and on his request, the state agreed to an extension of his stay in the States for practical training for 1 year. During this year, he came to India for a domestic visit, but was allowed by the state to rejoin his practical training. On completion of his training, he joined service in the United States, and the state claimed a refund of the scholarship money. He pleaded waiver on the part of the state, and the court held that there was no waiver whatsoever and M was liable to refund. The extension here was mutually agreed upon, and there was no conduct on the part of the state showing an intention to waive. So the difference between English and Indian laws was stated by the Calcutta High Court in Manohar Koyal versus Thakur Das Naskar. The court said it is quite clear that Section 63 not only modifies but is indirect antagonism to the law in England. It was laid down, as pointed out in the case of John Weston Fawkes versus Julia Beer, that for the last nearly 300 years, it has been the law in England that if A owes B 5,000 rupees and B consents to take 2000 rupees in payment of the debt, that is what is called a nudum pactum, and that B, after taking 2000 rupees, can subsequently bring his action for the unpaid 3000 rupees. The law in this country, however, by virtue of Section 63 of the Contract Act, is different. The point on which Section 63 differs from the English law is that it does not require consideration to support a release, while under English law, a release without consideration is a nudum pactum. Further, an important difference between Section 62 and Section 63 is that the former, which provides for novation, requires an agreement based on some consideration, but Section 63 requires neither. Under this section, as held in Jitendra Chandra Roy Chaudhary vs. S.N. Banerjee, the promisee may, before breach, gratuitously release the promisor from the obligation to perform the promise, and the promisee may, after breach, gratuitously release the promisor from his liability arising on such breach. As against this, under Section 62, novation agreement must be made before the breach of the original promise. Now, in relation to accord and satisfaction, we see that the accord is an agreement made after breach whereby some consideration other than his legal remedy is to be accepted by the party not in fault, followed by performance of the substituted consideration. The liability arising out of breach of contract may be discharged by accord and satisfaction. The validity of accord and satisfaction must be judged by the general law of contract, quite apart from the provisions of Section 62 and Section 63. The principle and effect of accord and satisfaction have been explained in this decision of Privy Council, that is, Payanna Reena Layana Saminathan Chetty versus Pana Lana Pana Lanna Palaniyappa Chetty. Of course, this is a South Indian case law. The facts here were such that the receipt given by the appellants and accepted by the respondents and acted upon by both proved conclusively that all the parties agreed to a settlement of all their existing disputes by the arrangement formulated in the receipt. Here it was held that it's a clear example of what used to be well known in common law pleading as accord and satisfaction by a substituted agreement. No matter what were the respective rights of parties inter se, they are abandoned in consideration of the acceptance by all of a new agreement. The consequence is that when such an accord and satisfaction takes place, the prior rights of the parties are extinguished. They have in fact been extinguished by the new rights, and the new agreement becomes a new departure, and the rights of all the parties are fully represented by. Now, the estoppel says acceptance of final bill. In such cases, for example, in Government of Gujarat vs. R.L. Kalethi and Co., where a contractor accepted the final bill without any objection and under the terms of the contract, such act had binding efficacy against him, it was held that the claim of the contractor for additional payments and damages raised 2 years after acceptance of the final bill was barred by estoppel. Now, lastly, we have the idea of material alteration, with which we end this topic, that is discharged by agreement. So the meaning of the expression material alteration has been considered by the Supreme Court in the case of Kalyanna Gondar versus Palani Bondar. Here, a memorandum of agreement for the sale of land under which Rs 2000 were paid in advance was with the plaintiff. The defendant refused to convey the land and pleaded that the plaintiff had altered the deed by adding the words that the seller shall clear the debts and execute the sale deed free from encumbrance. The plea was dismissed because the alleged alteration could not be proved, but Justice Shah took opportunity to point out that even if it be assumed that the sentence regarding encumbrances was written after the deed was executed, it will not invalidate the deed. Ordinarily, when property is agreed to be sold for a price, it would be the duty of the vendor to clear it of all encumbrances before executing the sale deed. The alternation, if any, cannot therefore be regarded as material. Materiality of the unilateral amendment is the most important factor. And for this, we have the authority of Build India Construction System versus Union of India, where a contract containing an arbitration clause the government made the unilateral amendment to the effect that the arbitral award must be reasoned. The alteration here was held to be not binding upon the parties. The government was not allowed to avoid the award on the ground that the award was without a statement of reasons. So students, that sums up this lecture. In the next lecture, we are going to continue with discharge by breach. Thank you.